Go ahead. Good morning. We welcome everyone to our October session held again via WebEx because of the continuing prevalence of the public health issues. We found that the previous two times we've done this, it's worked fairly well. As you've seen already, occasionally we have some minor technical difficulties, but usually they can be resolved. But we'll deal with those as they present themselves. The only thing I would say is that, as always, when your case is called, I'll say a few words to, in an effort to frame the issue. The court's fully prepared, it's had the briefs available. Typically, these present a discrete legal issue. We've selected them for review, and as always, you can rest assured that as we have the benefit of your brief, you need not worry if you think you've missed a point or two, because it's amply covered in the papers. With that, we'll call the first case.
The first matter is Renee A. Rice versus the Diocese of Altoona-Johnstown. Representing the diocese is Eric N. Anderson. Representing Ms. Rice is Mr. Alan Perrer.
Good morning again. This civil case involves alleged clergy sexual abuse that occurred in the 1970s and 1980. The plaintiff commenced her action after reading a 2016 investigative grand jury report concerning the occurrence of such abuse in her diocese and the measures taken to obscure it. Because the incidents in question occurred more than 3 decades ago, the action would ordinarily be time barred under the statute of limitations. However, the plaintiff maintains that the discovery rule, fraudulent concealment doctrine, told the limitations period so that her lawsuit was timely. The Superior Court ruled that these issues involved questions which should be submitted to a jury, and the defendants have appealed that decision. Mr. Anderson.
Thank you, Chief Justice. Good morning, Court. May it please the Court, my name is Eric Anderson. I represent all the defendants except for Father Bozak. He is not a party to this appeal. I want to thank the Court for accepting this appeal because it's a case that has significant impact on not only the immediate case, but on a number of cases that are pending in Pennsylvania, and it goes well beyond cases that have to do with statute of limitations and the discovery rule. We filed a request that this Court review this case because we believe that the decision by the Superior Court is not well-founded, that they misapplied the law, and that there are certain comments in the opinion that could open up completely new areas of the law that I don't believe that the law in Pennsylvania would support or would intend to follow. There are 3 issues that I raised in my brief on behalf of the diocese and the diocesan defendants. The first one deals with the ruling by this Court in Nicolau versus Martin. That was a medical malpractice action, but the Court found that there were discovery issues in there that required the Court to reverse the Superior Court, which affirmed the trial court, which granted a summary judgment. The Superior Court in the present case relied on the Nicolau decision of this Court to decide and hold that sub silentio, the Nicolau case overruled a long line of cases in Pennsylvania dealing with sex abuse matters in the church. Those cases are the Meehan case, the Basilis case, and all the cases that followed those cases that were decided back in the early 2000 time frame. Those cases stand for the proposition that under Pennsylvania law, if someone suffers a harm, they know they were harmed, they know who harmed them, and they know who the abuser or the employer was of the person who harmed them, that they are on notice to conduct a reasonable investigation and exercise due diligence in order to explore their claims. And it's not necessary, the statute of limitations to start to run, that they know all of the causes of action, all of the potential defendants, all of the causation issues. The law in Pennsylvania, and it's been the law for quite some time, is that a party, once they're put on inquiry notice, they have to conduct a reasonable investigation of their claims and then file a lawsuit as soon as they are notified or they have enough information to allow them to proceed with filing a lawsuit. The Superior Court, after reading the Nicolau decision of this court, decided that the Nicolau overruled all of the prior cases which dealt with the issue of abuse by a priest in a diocese. And that the Superior Court decided that all those, in essence, decided that anytime there's an issue concerning the discovery rule, that the case has to go back to the trial court on the issue of to explore a factual issue.
But Mr. Anderson, Justice Baer.
Yes.
Okay. And I wrote Nicolau on behalf of a unanimous court. I don't think that Nicolau necessarily, I think it's a distraction to talk about whether it overrules or doesn't overrule anything. Isn't it fair to say that Nicolau stands for the proposition that if there are factual disputes concerning the discovery rule, that a jury has to determine them?
Yeah, and I agree that is what Nicolau stands for, and I believe that this court properly decided Nicolau.
Okay, so the question then here really is whether, for discovery rule purposes, putting fraudulent concealment aside, is whether there's a genuine issue of material fact as to whether or not the plaintiff knew or should have known that the church was engaged in a conspiracy to cover up the Father Basilek's abuse. Fair?
Well, yes, but I think what the laws stand and has been and with Meehan Basilek's cases is that in a situation where you have the person who is harmed knowing who harmed her, knowing that she was harmed, knowing the employer of the person who harmed her, that she has to conduct a reasonable investigation, and there's no evidence in the record whatsoever that she made any effort to investigate this matter.
I agree with that. So to that extent, that's the Superior Court's analysis that Nicolau overrules Baseline and Meehan. And of course, those cases, we don't have a stare decisis problem. They're Superior Court cases, and they're not binding upon this court. So yes. The question, I guess, is, and I guess we're getting there here, is whether that's correct. Whether the fact that she obviously knows that she's abused, and she has till age 30, I believe. So she knows she's abused. She knows who abused her, and she knows it occurred on church property, as you point out. Whether that's enough to eliminate a factual controversy.
And I believe it does, because the law in Pennsylvania is inquiry notice. And once she knows those salient elements of her facts, then she has to make the effort to conduct an investigation, possibly initiate a lawsuit, and then she can explore all claims that she has against all potential defendants.
And I guess, go ahead and finish your answer. I apologize.
And there's no evidence that she did anything like that.
I don't want to dominate this, so I invite my colleagues, but it seems to me almost counterintuitive to think that she's on inquiry notice, because one would think that the priest did this on church property to protect himself from discovery. His home, the rectory, his church, etc. And I don't know that one would think prior to some point in time when it became public notice that the church would know anything about this. And one would think, it seems to me, that the church would that the priest would go to all efforts to keep this secret, to protect himself, that the church would know nothing about it because the priest kept it secret and the defendant kept it secret. So, I'm sorry, the plaintiff neither knew nor should have known that there was this vast looming conspiracy. And that's what sort of pushes me to the idea that the Superior Court got the ultimate conclusion correct, that there is a jury question here as to when the church knew or should have known. And that's what you need to overcome, at least on my behalf.
And I can appreciate that, and I certainly understand, the sympathies for a plaintiff in a situation like this. But I know, as you pointed out, Justice, that this court is not bound by Superior Court precedent. However, there are many cases that were decided in the Superior Court that follow Baselis and follow Mahan, where they decided that once you know who your abuser is and you know who the employer of the abuser is, you have an obligation to start to conduct a reasonable investigation. It's just like in a situation where a person's hit by a truck driver, and the person was injured, and they know who injured them, the driver of the truck. They also know who the employer of the truck company is, or the employer of the truck driver. And so they have an obligation to, at that point, to conduct an investigation, to explore whether or not there's some basis to hold the employer individually liable, because of failure to supervise, or negligent hiring, or negligent supervision. But when you have those basic elements of a case, that is what puts a party on inquiry notice to conduct an investigation.
Mr. Anderson, could I jump in there and ask you a follow-up question, please? Aren't you addressing a different theory? Isn't the plaintiff's theory in this case that she was put on notice by the grand jury report and its revelation about assignments of clergy to conceal what was going on, and the cover-up that was asserted in the grand jury report, and that was what triggered her investigation? Isn't that the plaintiff's theory rather than the theory of those older cases been invoking?
Well, I think, Justice, it's a little bit difficult reading the plaintiff's complaint to figure out exactly what the theory is. The plaintiff's amended complaint contains 3 counts: fraud, constructive fraud, and conspiracy. So when you read the complaint, you have to figure out, well, what is the fraud? And what is the fraud that resulted in a harm to the plaintiff? And the only fraud that could have resulted in harm to the plaintiff is a fraud which would have been perpetrated because the diocese allegedly knew that Father Bozak had abused somebody in 1971. And they did not notify the parishioners. They allowed him to stay in his position as a priest in the church. Therefore, and as a result, Miss Rice was allegedly harmed. So the fraud was keeping from her the knowledge that they had of Father Bozak, and that fraud is what resulted in the harm. The fact that she read something 30 years later does not change the fact that the underlying fraud happened back in 1971, or excuse me, 1981. I think what's very significant also is that in the plaintiff's brief on page 8, footnote number 2, the plaintiffs acknowledged that the statute of limitations on their fraud claim expired. Their position is that the only issues before the court are the issue of the discovery rule and the issue of constructive fraud or fraudulent concealment. Well, if they acknowledge that the statute of limitations expired on their fraud claim, then there is no basis to support the underlying fraud, which is the one that resulted in her harm, and that's really what she is seeking compensation for is a fraud, not the fact that she found out 30, 40 years later about what happened. It's what happened back when she was harmed. And as Justice Bear pointed out, Bozak is hiding the information. It have it on church. The diocese probably didn't even know about it. In fact, if you read the plaintiff's complaint, you'll see that the allegations, the pleadings, are that in 1993, the diocese found out that Father Bozak had allegedly abused somebody in 1971. And in 2000, and based on the grand jury report, the 37th grand jury report, it was in 2003 that the diocese found out about Father Bozak having abused someone in 1971. So how could there even be a fraud back in 1976 through 1981 if the diocese had no knowledge whatsoever that Father Bozak had allegedly committed or had harmed people earlier than he harmed the plaintiff? How could there be a fraud to keep that information from the plaintiff when the diocese didn't even know about it based on the pleadings until 1993 at the earliest, and then perhaps 2003 based on what is reported in the grand jury report?
Counsel, this is Justice Donahue. Can I follow up on Justice Buck's question? The plaintiff is claiming that her discovery took place with the publication of the grand jury report in Pennsylvania. My question to you is, starting in approximately the year 2000, there was widespread publication of information regarding abuse by priests within the Catholic Church, dioceses within the United States and in other countries having knowledge of that abuse, and the failure of the Church to do anything, and in fact, to cover up the abuse. Spokane, Washington, various places in Oregon, parishes in Louisiana, all declared bankruptcy between the years 2000 and 2010. Does that information that permeated the press at the time raise inquiry notice on the part of the plaintiff to investigate the possibility of that same type of action taking place within the Commonwealth of Pennsylvania and her diocese?
Yeah, absolutely. There was a great deal of publicity about priest abuse cases throughout the entire country. More specific, with respect to the Blair County, where this incident occurred, I'm sure that the justices and are aware of the Hutchison versus Luddy case that received extensive coverage. It was a case, I think, went to trial in 1990, maybe 1994, in Altoona that lasted 5 or 6 weeks, and there was daily publications of that reports of what was going on in that trial. And as Justice you just pointed out, that's just one simple area. This was all over national news. And so there's no reason why she should not have been placed on inquiry notice that maybe I should explore my claims against the diocese, not just Father Bozak.
Well, Counsel, the theories in the cases upon which you rely that arose out of the Diocese of Philadelphia, they pled essentially the same theory that we're seeing in this case. Similar cases were brought within courts of common pleas in Lehigh County. raising the issue of complicity of various dioceses and the Catholic Church in general in the cover-up of the pedophilia within the ranks of priests in the church. Are those cases that date back to 2005 and 2006? Do they place the plaintiff on inquiry notice of similar activity within her own diocese?
I think absolutely. Again, I mean, that's information that the diocese, respective dioceses, were aware of abuse of priests in their employ, and that so that there was no reason for her not to believe that perhaps I should investigate this diocese, Altoona-Johnstown, and find out what they knew. There's been discussion in some of these cases about the secret archives. Well, the discovery in the Hutchison case, they found out about the secret archives, and that again was in the early '90s, and so that information could have been developed had she conducted any type of reasonable investigation. There's another case that's the Commonwealth versus, I think, Stewart case, and that was in 1997, where there was a question concerning the background of a priest, and they asked, there was discovery and there was a request for documents, and the information came out about the secret archives, and so all that information was provided. So I think there was more than sufficient notice to the general public, and specifically to the plaintiff, since she was abused.
Mr. Anderson, Tom Saylor,
Yes.
we're going to start winding this down, but I had a question. Well, within the statute, couldn't the plaintiff have sued both the priest and the priest's employer, namely the diocese, on a theory of vicarious liability?
Well, absolutely.
Without anything else. In other words, the theory is the employer is responsible to supervise the employee, and you have your lawsuit well within the statute.
Yes, she certainly could have done that. And then, like the example I gave about a trucking company, once the lawsuit is filed and they get access to documents, then there might be different theories or new theories that could be developed. And so if there's no reason why she could not have done that, if she elected to, instead of waiting, 35 years before there's a publication of the grand jury report.
Mr. Anderson, as the Chief Justice said, we're probably going to wind this down. So out of fairness to you, you may want to say a few words about the fraudulent concealment doctrine. So let me maybe leapfrog, because I thought the 2006 letter went more to fraudulent concealment than it did to discovery. Although you could still make the argument that the 2006 letter duped, and I don't mean that malevolently, but took the plaintiff off her discovery guard by saying, we're shocked to see this. Why don't you call our victim's advocate and maybe appear in front of the Allegation Review Board? Again, arguably, and this is why the question is whether it's a jury question, obfuscating that there was this conspiracy on behalf of the diocese. So you might want to talk about that letter.
Thank you, Your Honor. With respect to that particular theory, constructive fraud or fraudulent conspiracy, that concept comes into play when there's a special relationship. Now, the plaintiffs have pled that the special relationship was created back in the mid-'70s, early '80s, when the plaintiff was at the church and played the organ and helped the church, and therefore there was a special relationship which created a duty on the part of the diocese to come forward with information. I believe that's the way that the Superior Court phrased it. Well, the special relationship at some point in time has to end. It doesn't just exist forever and ever. And even if it did, to your point about the letter in 2006, when excuse me for a minute, if you go back, the complaint says that the first time that the diocese was aware of her being harmed was in 2006 when she notified the diocese. That's in the pleadings. That's on, I think, paragraph 43 of the amended complaint. And then the letter is attached as an exhibit to the complaint. Well, that's the first time that the diocese became aware that she was a victim. So how can there be this duty to have disclosed information concerning Father Bozak or whatever priest would be involved when they never even knew that there was that she had been a victim? And again, you have to look at her as an individual, not look at the general population. And that letter was coming forward, and if there was an obligation, a fiduciary obligation, for the diocese to come forward and tell her about Father Bozak, that letter did it. That letter said, and I know the plaintiffs like to couch it in the terms that it was additional, I think, obfuscation that you mentioned, or a different, and a further attempt to dissuade her from suing the diocese. But that letter said very simply, we know we are investigating your abuser. We know that he abused somebody else. And during the course of our investigation, we found out that he abused you. So please assist us in the investigation. I don't know how much more notice you could give to somebody than what the diocese did in that letter. I mean, the plaintiffs would have the diocese draft a complaint and send it to her with all the facts and say, okay, take this complaint to an attorney and file it. But that letter certainly put the plaintiff on inquiry notice at that point in time when they're investigating the very abuser and investigating that he abused other people. And for her to, again, do nothing, absolutely nothing for 10 years, I think is contrary to the law in Pennsylvania. I think she was on inquiry notice, and she had to have taken some action shortly after 2006 to file the suit timely.
Thank you, Mr. Anderson. I think we'll turn now to Mr. Pear on behalf of the Aplt plaintiff.
Thank you, Court. Thank you for your attention.
Thank you, Chief Justice. My name is Alan Pear, and it is my honor and privilege to represent Renee Rice in this matter. May it please the Court. In essence, the diocese is seeking this court to hold that in all cases involving sexual abuse, regardless of any factual dispute as to when the plaintiff knew the cause of her injury, and regardless of any concealment by the diocese, the statute of limitations begins to run as a matter of law as soon as the plaintiff knows the identity of her abuser and the abuser's employer. The diocese argues that here, Renee Rice's claims were untimely as a matter of law, and they seek to continue the mechanical application of the Meehan and Basilis cases, which paid lip service to the correct principles of law, but erred in their application. Renee Rice is not looking for any special rule. She's not arguing that her claims are timely as a matter of law. She is simply asking the court to apply the same discovery rule and fraudulent concealment principles to all cases, this one included. That is to say, when there are issues of fact as to when the plaintiff was on inquiry notice of a cause of her injury, or whether the defendant misled her as to that cause, those issues are specifically reserved for the jury. She alleges she did not know and was not reasonably knowable that the diocese was the cause of her injury until she read the 2016 grand jury report. She alleges that the diocese made affirmative statements concealing that it was a cause of her injury and that a confidential relationship existed between her and the diocese. The diocese alleges facts on its side. In all cases, every case decided by the Superior Court regarding the discovery rule, where there are such factual conflicts, it has long been held that resolution of those conflicts is for the jury. We're simply asking that the same rule apply here.
Counsel, this is Justice Donahue. I'm not certain that what you just stated is in fact the discovery rule in Pennsylvania as you know it. We've looked at this issue repeatedly over the years, primarily in the context of medical malpractice cases, which presents a little bit of a different issue because of the need for certificates of merit. But my understanding of the discovery rule in Pennsylvania is that once an individual is injured and knows that someone else is potentially responsible for that injury, he or she has 2 years in order to investigate and determine who is responsible and what causes of action exist. So in this case, we know at the time of the abuse that the plaintiff was aware of the fact that she was injured and that someone else was potentially responsible for that. Why does not the rule as we have adopted it in Pennsylvania for discovery apply in that case, giving her 2 years to make a determination as to whether or not there were others other than the priest who were responsible for her injuries?
Yeah, thank you, Justice. Because in this case, and if you look at every single case that has come before the Supreme Court, and they do not just limit it to medical malpractice, there's product liability, there's legal malpractice, there's property damage. Every single case, the plaintiff has to be put on some kind of inquiry notice as to the cause of her harm. And there is a factual dispute as to whether anybody would assume that her church would be countenancing pedophile priests to abuse the people in the church and children and allow that to happen and cover it up and conceal it and move these priests around. And as Judge Weddick said, in the same case where the judgment on the pleadings was granted here in the Rice case and in the Meehan cases, at the same time, he said, I have a matter to believe that it would be far-fetched for a plaintiff to even conceive that this massive cover-up, this massive conspiracy, this massive permission of allowing priests to abuse children for years and years and years would ever have occurred in their church. And
I can follow up on that. So because it is unlikely that a plaintiff would discover alternative causes of the harm, the duty of due diligence does not exist.
No, I don't think that's correct.
That's what I'm trying to understand.
The duty, yes.
You may be right. The problem that I'm having with this is the rule that the Superior Court explicitly adopted in this case is precisely the rule that this court refused to adopt in the Wilson case. So we don't have a rule where you get an endless period of time to discover all of your causes of action. Let me ask you this question. There's a motor vehicle accident. Plaintiff is rear-ended by a defendant, files and does nothing. Finds out 5 years later that the brakes on the car of the defendant's vehicle were defective. Does that plaintiff then have the opportunity 5 years later to file a lawsuit against Ford Motor Company for defective brakes? Or that cause of action had to have been discovered during the 2-year period that you get in order to investigate once you're injured and you know that potentially someone else is responsible for that harm?
Yes, I mean, I think in that case, you're talking about a derivative claim from the actual harm itself, the actual accident and the actual thing that occurred, which is like the battery in this case. And that's a separate issue, whether or not someone else is responsible for the battery. But there's a completely separate.
And I'm really trying to work through this with you. How is that a separate issue? There's an injury, there's a motor vehicle accident. Plaintiff suffers significant back injuries, knows that there was a defendant driving the vehicle who rear-ended her. Why does that plaintiff not have to determine within the 2-year statute of limitations that Ford Motor Company put defective brakes in that vehicle, which was also a cause of that accident?
Well, I think in that case, there would be some obligation, but where you have a situation where there has been concealment and there has been an inability, let's say Ford Motor Company.
That's a different issue. Concealment is a different issue. I'm just trying to hone in on the discovery.
Yes, and I agree. And it's in the discovery rule has two facets. It's when a plaintiff is placed on inquiry notice of a cause and where the plaintiff reasonably could have discovered the cause. It's a second point there. And where it took until the 2016 grand jury report, where the police, the district attorneys, CYS, all the social service agencies, nobody had discovered the fact that there was a massive systemic conspiracy cover-up to allow victims to be children to be abused repeatedly. It raises the second issue. Was she on reasonable inquiry of something so unknowable that or not? And that's a jury question.
I'm sorry, Justice Donahue, did I interrupt you?
Oh, go ahead. Thank you.
I wanted to follow up precisely on your point, which I think is very well taken. So Justice Donahue gave you the example of the truck driver, but we can give you 1,000 examples as you could give us. The Med-Mal case, where the alleged malpractice occurs in the hospital, and the plaintiff knows that they had an unsatisfactory result, and they come to see you. It seems to me that what the plaintiff arguably did wrong here was she didn't seek counsel, because I think any counsel, and competent counsel, and you certainly are, as many other are, that one of the first things they're going to do in Med-Mal, look at the doctor's credentialing, look at the doctor's prior record. In the truck driver, did the employer know, or should they have known that he was a drunkard, or that he had an accident? And here, it seems to me the plaintiff's lawyer would look at what did the church know. Well, maybe the plaintiff's lawyer doesn't find out, and then there's a different cause of action, which I understand. But you know, it's what Justice Donahue's getting to, which is inquiry notice, premised upon the idea that it's pretty basic that when you have this, you look to, and the Chief Justice mentioned it with vicarious liability. You look at the employer right away, but she never sought counsel.
Well, that I think you have to look at, as they say, it's a reasonable standard, a reasonable diligence, and that reasonable diligence takes into account the person's individual characteristics, who they are, and those are all factual questions. How do you reconcile? You know, you're talking about these medical cases. How do you reconcile the case with the Lyme disease? I mean, obviously there's facts where the plaintiff was told. She came before the Superior Court after summary judgment. She was told this is likely Lyme disease. You need a test. Doesn't do it. This summary judgment was granted against her on the discovery rule. This court said no. It goes to a jury.
We don't have to argue that case. She was also told on innumerable occasions.
Well, I'm going to say to Justice Donahue, you're talking about all these things published. Look at the Risperdal case. I think you wrote the opinion on that case. There, in that case, it was on the TV. They changed the label on the drug. But these are all questions as to when the plaintiff was placed on reasonable notice.
Counsel, this is Justice Doherty. Let's talk about this case in reasonable notice. Share with me why this court should not assume or find as a matter of law that on July 17, 2006, when the church responded back to Ms. Rice suggesting that she contact Sister Welch and appear in front of the Allegation Review Board based upon the two-pronged test in Pennsylvania. Why should that not activate the inquiry notice such that she had until 2008 from 2006 to file her complaint?
Because that, actually, I look at it a different way. That they did not reveal, as Mr. Anderson said, oh, we told her, we were informed in 1993 that Father Boziak had abused another child in 1971. She was never told that. Actually, they covered up again. They had notice prior to 2006, 1993 in the grand jury report, they had notice that he had abused another child. When she came forward, they didn't say, oh, we know about this guy, and nothing was ever done. Nothing was ever done until 2016 when he retired or left the ministry.
I apologize. Are you asking us to find this discovery rule as an exception to the statute of limitations as opposed to the accrual of a claim?
No, I think that's exactly what it is. It's the discovery rule is statutory interpretation of when does a cause of action accrue, and it accrues when you know you have reason to know not only of the injury but of the cause, and the cause in the diocese standpoint is that they covered up and allowed a priest to continue to operate as a priest with children, knowing that he was a pedophile. Now that is, can I just finish? That is, I think we're confusing two things here. Even though the jury would have to decide whether or not the discovery rule was told because she was not placed on inquiry notice, or that she couldn't have discovered, or that there's been a concealment, she still has to prove the fraud. She still has to prove the constructive fraud in the underlying case. And so the discovery rule is based on knowing the cause of your injury, not the cause of action, if that makes sense.
Mr. Parrott, Justice Todd, I want to go back to that 2006 letter from the diocese and the discovery rule, not the fraudulent concealment. As Mr. Anderson sets forth, that letter did provide notice sufficient to invoke a duty of inquiry, notice of inquiry to the plaintiff. You have a different view of that 2006 letter. It almost seems like we're talking about two different letters. I assume the letter's in the record.
Yes.
So could you, I know you answered, pardon me, I know you answered one question about your view of the letter, but my question is simply about the contents of the letter. You seem to be talking about a different letter than what I heard from Mr. Anderson.
Well, the letter did not reveal. I urge the court to review the letter. The letter did not reveal that, in fact, the diocese had received prior notice of Boziak's abuse of children in 1993. It didn't say anything like that. We know about Father Boziak, and we're glad you're bringing this forward, and we're going to take action to do something here. The letter just said, we received your complaint about your abuse, and we're going to investigate it and turn this over to our coordinator, which the grand jury said was basically a shill for the diocese to protect them from liability. It wasn't to.
Well, look.
So there was a concealment at that time that they actually knew about. They had actually received another report earlier. And so she had no idea. She was just making a report and assumed they were going to investigate it. She didn't know anything about a concealment. She didn't know anything about a cover-up until the grand jury report.
Thank you.
Counsel Donahue again. After she received the 2006 letter, did she take the diocese up on their invitation to participate in their investigation?
No.
Didn't she have?
She lived in. I think she lived in Tennessee, and did not. But she never heard back from the diocese about that they did an investigation or that they discovered anything. She put them on notice that she had been abused, and this letter, this self-serving letter like, oh, we're just learning about this, Father Boziak, you can meet with the coordinator and give more information, and nothing to do with their response where they concealed the fact that they already knew about him. And they allowed him to continue as a priest from 1993 on.
Yeah, but counsel, let me get back to my question. Didn't she have a responsibility, due diligence, so to speak, to participate in the investigation when requested by the diocese to do so? You're asking us to essentially say that there is never a statute of limitations defense as a matter of law. You're asking us to say that there was never a point in time when the plaintiff had the obligation to exercise due diligence within some 2-year period of time. And that's how the Superior Court read the Nicolau case. That's not what the Nicolau case said. That does not do away with the possibility of there being a statute of limitations defense as a matter of law. You mentioned the Risperdal case. One of the issues that was raised in the Risperdal case, and I did in fact write that opinion, was the fact that there was such significant media attention concerning the use of this drug that the plaintiff was put on inquiry notice. And we discussed it at length and found in that case that there was not sufficient media attention to raise that defense as a matter of law. But we never said in that case that there isn't a situation where there may be enough media attention to put a plaintiff on inquiry notice as a matter of law and trigger the 2-year period of time. So is there ever a point in time prior to the grand jury report in 2017 or whenever it was, that this plaintiff had an obligation to do her own investigation as opposed to relying on a government investigation?
I think these are questions for a reasonable jury to decide. Yes, there are going to be situations where there are no material facts that would allow a plaintiff to delay to a certain point inquiry notice. But for example, Justice, when you're citing all these things and they cited in their amicus briefs, oh, look, here's law review articles and this, that, we aren't even to the stage where these factual issues could even be explored, because unlike any other case that has come before the Supreme Court, this was decided on a motion for judgment on the pleadings. Every other case that has come before this court under the discovery rule and fraudulent concealment, this court has reviewed the factual record that has been developed and determined whether or not there are material issues of fact to go to jury. This case comes before you based on the pleadings and the complaint, which have to be taken as true. And in the pleadings and the complaint, she's saying there was nothing to put her on inquiry notice. Now, certainly they deposed her, and we can ask these questions. And why didn't you know about the articles in the newspaper, or why didn't you know that there was a conspiracy or cover-up? She'll answer those questions. And if there's no material issue of fact, then it's possible that it would not go to a jury. But every case that's come before the Supreme Court, every single case starting with fine, every single case has involved a balancing of the material issues of fact concerning when a plaintiff should have known that what caused her injury and had the means to determine that, and it becomes a jury question. It is not a matter of law. I think what you're saying is, we're not asking the court to rule as a matter of law on that she's within the statute of limitations. All we're saying is to follow the Supreme Court precedents set forth in both the discovery rule and fraudulent concealment, and let those matters be determined by jury. The diocese still could win. They could take that position. They could say, well, you knew, and maybe she'll admit it, who knows? But let a jury decide the issues, because we have competing facts exactly on that issue.
Counselor?
This is Tom Saylor. Like in the Lyme disease case in the discovery rule, the woman didn't know that she had Lyme disease, so she couldn't sue the physician. This woman knew she'd been abused, so she could have sued the priest.
Yes.
And if you sue the priest, typically you sue the employer. Like if there's a member of the judiciary that's abused someone, typically they'll sue that individual and they'll sue the judiciary as the employer. And you can do that well within the statute of limitations period.
Well, that's true. I mean, she could have sued for the battery. She could have sued, and she could have sued for respondeat superior, or she could have sued, and she could have sued. Of course, they're not vicariously liable for the battery usually, because it's outside the scope of employment. Yet that's not the issue. We're talking about the diocese here as being a cause, and nobody. I submit that it's a factual question for anybody. So
the damages be, in other words, as a practical matter, there's a couple practical issues here, as always. As a practical matter, even a direct suit against the priest, whatever the damages are, the diocese is going to indemnify the plaintiff for the verdict, I would think. And secondly, if you too severely attend the discovery rule, no insurance company could sell insurance because you couldn't compute the reserves.
Well, let's put it this way, Your Honor. I think as we get further and further away from the grand jury report, the grand jury report really, the one that was in Altoona-Johnstown and the one that was in Allegheny County and Pittsburgh Diocese, they exposed a massive fraud, cover-up, concealment, whereby systemically multiple priests were allowed to roam free and abuse children. Nobody knew of this, and that put her on notice. This is a totally different situation. As we get farther and farther away, Your Honor, from the grand jury reports, it will be less and less tenuous that a plaintiff
would be 2 years, because if that's the starting point,
that's right.
The
That's correct.
statute starts in Pennsylvania with the release of the grand jury report, and it should be cabined at 2 years.
That would be a good argument to the jury, and may actually succeed. But it's not as a matter of law.
Why would you have to argue that to the jury? Under your theory, everyone knew when the grand jury report was released. That's your theory, unless I'm missing something.
I'm not saying
that even then you have to have a statute of limitations.
Well, I'm not saying everyone knew at that point. I'm saying for Renee Rice, that's when she learned. That's when she learned of it.
Thank you.
Counselor Justice Donahue, one more time, a legal question for you. Let's assume that we get to the issue of the parishioner plus rule that was adopted by the Superior Court. If in fact we would adopt that rule, could it only apply prospectively, since we would in fact be divesting defendants of their right to a defense that had vested? I mean, it's the reason, for example, that all of the statutes that our legislature has attempted to enact aren't applying in this case, because they didn't want to divest vested defenses that defendants had. So if we, for the first time, adopt the parishioner plus rule, could that only apply prospectively?
Your Honor, I disagree that they adopted a standard that the confidential relationship only would apply if you have a parishioner plus rule. I think that was a term that was used to basically characterize the confidential, the facts of the confidential relationship that she developed. I don't think they set a standard, say you only if there is parishioner plus are they required to have do they have a confidential relationship at all? I don't think they adopted that.
Counsel, let me just follow up on that, because I understand the notion of a fiduciary duty potentially between a priest and a parishioner in a situation where you have a parishioner who is intimately involved in the workings of the parish. In order to get to the diocese in a confidential relationship setting, do you not, in fact, have to go well beyond where we are? I mean, I'm not aware of any case in Pennsylvania that extends a fiduciary relationship to an institution, as opposed to between individuals who are involved in a relationship.
I'm not sure I understand the question, but I think that the confidential relationship in this particular case, the court cited various factors that have been considered in other jurisdictions and such to be lumped under this title of parishioner plus. The jury would have to make a determination based on the particular facts of the relationship between the victim and the diocese as to whether or not they were in a situation where there was superior authority and they relied on them, and whether they had a confidential fiduciary duty to not be silent when they knew certain information, such as the fact that there was abusive priest being put in touch with a child. I don't know, Your Honor. I'm not sure I understand the question.
Mr. Pear, Justice Pear, and I just want to we're about done, and I want to follow up Justice Donahue. Assume for a second that this court declines to adopt parishioner plus, or refuses to, or declines to adopt the idea that there can be a fiduciary relationship between an institution and an individual. Does that conclude, is that fatal to your fraudulent concealment argument because you're lacking an affirmative action of concealment from the diocese, or can you nevertheless go forward on fraudulent concealment on some basis?
Well, I would, number one, I would be surprised if this court would, as a matter of law, make a ruling that there cannot be a confidential relationship in a particular case such as this, because that would be contrary to everything that is, all the jurisprudence that has come down and say these are factual questions. We're not going to draw any fixed lines as to what is a confidential relationship and not. But in answer to your question, however, it has been pled that there were affirmative representations made that the priest was of good standing, that he was ethical and moral, and that it was safe to trust your children to him. So I think there were affirmative, at least it was pled, there were affirmative representations also, in addition to the silence requirement to speak if you have a confidential relationship.
Thank you.
Thank you, Mr. Parra. Thanks to both counsel. Very ably presented. And with that, we'll conclude the argument and take a 5-minute recess and then call the next case.
Thank you.
Ready? This matter is David Clark versus Jeffrey Stover Esquire. Representing Mr. Clark is Matthew Weisberg. Representing the appellees is Miss Kimberly Boyer Cohen.
Good morning. In this matter, the plaintiff alleged that his attorney malpractice in relation to the underlying litigation. The malpractice lawsuit was filed shortly after the attorney-client relationship ended, but long enough after the alleged malpractice occurred that the tort and contract limitations periods had already expired. The plaintiff asked this court to adopt the continuous representation rule, under which the statute of limitations would not begin to run until the date the attorney-client relationship is terminated. Mr. Weisberg.
Mr. Chief Justice, Associate Justices, and may it please the court, my name is Matthew Weisberg. I represent David Clark, the petitioner, appellant, plaintiff, both in his individual capacity and his representative capacity for the estate of Monica Clark. In my time allotted here today, I would like to go through not what the virtues of the continuous representation rule are, but what may the court find as the impediments to its implementation. The first would be, as respondent suggests, the Moore v. Juvenile case, which is a 150-year-old case. My research indicates never been cited. The absence or the rejection of the continuous representation rule was in the last paragraph of that opinion. I would suggest it's dicta. It certainly was not relevant to the holding of that case, which involved estoppel principles, tolling principles that were addressed in this case by the Superior Court. The question presented here is solely the continuous representation rule. To the extent this court finds that Moore v. Juvenile should be dispositive here, we would ask it for it to be reversed or overruled. Times have changed, and we will get into that further. The second issue I'd like to discuss very briefly is the Superior Court erred in finding that Monica Clark's claim was barred as waived. The third issue I'd like to discuss is why an extended or tolled statute of limitations would not be would not be stale, consistent with the statute of limitations. And the fourth issue I'd like to discuss is the extrajurisdictional cases on point, which are uncontested. In the first instance, the Moore v. Juvenile case, as we discussed, is a 150-year-old case, which my research indicates and respondent has not indicated, has never been cited before. It certainly has not been cited for the proposition that respondent holds it for. And I would respectfully suggest to this court that its last paragraph is dicta. That is, that it was not necessary for the holding in that case. I'm sorry, Justice Donahue, were you speaking? No? Okay, I apologize. We get notices when Justice is speaking. Anyway, the Moore v. Juvenile case, the respondent holds as dispositive. And we would respectfully suggest that it is not dispositive. But to the extent this court finds that it is dispositive, we would suggest that it be overruled. Times have changed. The times 150 years ago were much more client-centered. For example, the PBA, Pennsylvania Bar Association, has filed not on behalf of the petitioner, but on behalf of the respondent, an amicus brief. I suggest to you that that shift of 150 years, or likely of 150 years, is further indicative of why the Moore case should be, if not found dicta, should be overruled. For example, the mission statement of the PBA part of it is to promote the administration of justice, to see that no one, on account of poverty, is denied his or her legal rights, and to uphold the honor and dignity of the bar. By joining with respondent, I see no application of its mission statement to this case.
Can I interrupt and ask this question, Mr. Weiser? Rather than discussing the mission statement of an amicus, why don't we focus on the test you want us to declare? First question I have in that regard is, why in this context don't the fraudulent concealment and equitable discovery or discovery doctrine do the work you need to have done?
Very simply, respectfully, the Superior Court held that it did not. That the occurrence rule, which perhaps is an argument for another day, of the knowledge of the plaintiffs of their attorney's neglect surmounted all the other equitable tolling principles. The Superior Court, we ran through each one of the equitable tolling principles that would have otherwise told the statute of limitations, and we would not be here. But the rule we would like the court to adopt is that the statute of limitations is told until the attorney-client relationship is terminated, provided that relationship is related to the subject matter of the underlying representation.
But aren't there just innumerable circumstances in which there's no definitive declaration? I mean, it's very rare that a lawyer would send a letter to a client saying our representation or our relationship is now terminated. Certainly outside the context of legal malpractice allegations. Is there no transactional standard that ought to apply such that a person, such as your clients in this case, for example, would be on notice, whether in 2008, 2009 here, knowledge of a claim that's going to be lost? I just don't know what, how this representation rule would apply in practice in this Commonwealth. Think of all the outside general counsel relationships which exist, of certainly of an informal nature rather than a formal nature.
Your Honor, the practice of sending file closing letters, respectfully suggested, is very common and in fact encouraged amongst members of the bar. That the file is closed and our representation is terminated is something that is not only common but encouraged. But in terms of the second part of Your Honor's question as to the informal nature of the relationship, general counsel, for example, advise on many different topics, but that's not the rule that we're suggesting. We're suggesting that the relationship being related to the subject matter of the underlying representation. I hope that answers Your Honor's question.
Counsel, Justice Baer, you would have us overrule the Glenbrook case from the Superior Court, which we PCA'd, which does not have any precedential value. Is that correct?
Your Honor, it's my suggestion that that case need not be overruled. This court did not adjudicate the continuous representation rule. What happened was that the Superior Court declined to adjudicate the continuous representation rule, saying that it is for the Supreme Court. The Supreme Court then affirmed the Bosang Superior Court's opinion in a per curiam decision, which we suggest in any event does not have much weight. But I don't believe it needs to be overruled at all, because all that the affirmance, if it were given much weight, would hold is that it is not up to the Superior Court to adjudicate such lofty principles such as the continuous representation rule.
All right, thank you. I have two other questions that are related to one another. The first is, why are you picking on lawyers? The continuous representation rule actually began, if I understand its origins, from Med-Mal. But I can think of architects who design and then supervise the building of complex projects, office buildings over a period of years. I can think of CPAs involved in mergers and acquisitions over a period of years, and obviously doctors who treat a patient for years and years and years, and probably many other professionals. So why do you espouse this rule for lawyers and for no other professionals?
Well, Your Honor, we're here on a narrow professional basis, which is on the legal malpractice profession. I leave it to my Med-Mal colleagues or otherwise to bring a matter before this court that may, in fact, change that rule. But that said, this court in the Breyer case, which we cite in our reply brief, has already stated that attorneys are different. We are held to ethical standards that are lofty and enforced. We are held to the Supreme Court's standards, and the Supreme Court in the Breyer case has held, for example, that the unfair trade practices, the Pennsylvania codification of fraud or fraud-like behavior does not apply to lawyers. Lawyers are in a contractual, legal, fiduciary obligation, which is unlike most, if any, other professions. That said, I'm picking on lawyers, and we're picking on lawyers, because times have changed. In the legal 20 years ago, I used to read about community legal services, wills for heroes. I used to read about attorneys winning great verdicts for their clients. Now, 20 years later, I read about non-attorneys potentially becoming shareholders in large law firms in other jurisdictions. I read about mergers and acquisitions between law firms. I read about the business of law surmounting the practice or the professionalism of law. I see legal malpractice cases on the rise. There has been a shift.
But we're talking about your case. Can I just briefly jump in? What we're talking about your case, not how the world exists. And in this case, you've got a list of perceived defalcations by counsel going back to what, 2008? And so we're supposed to take this case as a vehicle to set up this large-scale CRR when in your case, not in what's going on in the world out there, but in your case, your client was on, according to your allegations, was on constructive notice going back years.
That is correct, Your Honor. And I'd suggest to the court that the continuous representation rule saves the harsh occurrence rule. Under the occurrence rule in legal malpractice matters, which is widely considered, the client is obligated, once an occurrence begins, to fire their attorney prior to their damage and pursue a legal malpractice case against that attorney in any other attempt to avoid mitigation or curative efforts or the ongoing confidential nature of this relationship. In this case, for example, you'll see that the case was begun on behalf of David Clark. The attorney committed malpractice. The Superior Court held that David Clark was on notice of that malpractice. What did the attorney do? The attorney then represented Monica Clark in a conversion matter for substantially the same issues. I suggested to the Superior Court that it is that type of conduct where the attorney leads the client into sitting on their rights, which in that case, or this case, would be suing their attorney, is an equitable tolling principle.
Although, I'm sorry, it's Justice Baer. In fairness to Justice Weck's question, let's not forget you have 2 years to wait for a natural break in the sequence of the lawsuit or the transactional analysis by the lawyer to retain new counsel to bring the case. But I wanted to follow up on Justice Wecht in any event. And I think actually not so much this question, but his prior question. And I think what he said to you, and I thought very astutely, was it's sort of staggering what you suggest. So you have and I think this is in the briefs, you have somebody who writes a will, and 50 years later it's probated and we find out there's a problem. Now, 50 years afterward, the malpractice is brought over under this continuous occurrence rule regarding the will. In family law, which many of us know, you have 18 years worth of custody or 18 years worth of support. But we've actually on this court seen civil cases that have lasted 20, 22 years. So aren't we going down a road, and again, I think Justice Wecht said this to you, but I want to just try to be more pointed, going down a road, if we adopt your proposal, where we have stale cases, no witnesses, very poor memories, 18 years later, 20 years later, 50 years later?
Your Honor, I respectfully agree that I'm asking for a sea change. But that said, to answer Justice Wecht's question as clarified by Justice Baer, the sea change I'm asking would actually lessen the amount of cases, not bring them more, which is to say that an attorney's curative efforts may prevent the malpractice or mitigate the malpractice. But in terms of the statute of limitations standing for the principle of not stale claims being brought, I would suggest that other jurisdictions, in fact, in the Moore case 150 years ago, which we were just discussing, it appears from that case that the statute of limitations was 6 years. In New Jersey, the statute of limitations is 6 years. In the other jurisdictions, the continuous representation rule is adopted, and the fear of stale claims is surmounted by our obligation to our clients, and our clients' obligation to us to rest their concerns about any occurrence, or I might add, perceived occurrence, which may not be true, into a trusting hand. Yes, it is possible, as Your Honor just suggested, that 22 years down the road, a legal malpractice claim would be brought. I can suggest to this court, having practiced in New Jersey where there's a 6-year statute of limitations, it just doesn't, it respectfully just doesn't happen. But to the extent that it can happen, yes, that is possible. But it's.
Let me ask you one more question, and this is purely pragmatic. I thought this case maybe should be dismissed as improvidently granted, because at least as to David, and I don't have Monica right in front of me, we denied Altoona on his merits case on May 16th, 2012, and the complaint in this matter was filed on October 1st, 2015. So even if we adopt continuing representation, if that representation ceased when we denied Altoona, he didn't make it within the 2-year statute of limitations anyway.
Your Honor, there are 2 statutes of limitations for legal malpractice. The first statute of limitations is legal malpractice negligence, which is a 2-year statute of limitations, and legal malpractice breach of contract, which is a 4-year statute of limitations. And so I would respectfully suggest that David's claim, severable from Monica's claim, but David's claim would not be stale.
And is Monica's claim stale? And I don't have those dates in front of me right now.
If Your Honor would allow, let me check my chronology.
Well, we can straighten that out later also, Counsel. I just curious as to whether or not the court gets into opinion writing in this matter based upon what was occurring. But we'll find that out for you. You don't have to do it.
Yeah, Mr. Weisberg, we certainly apprehend both your argument and your request that the court adopt what's known as a continuous representation rule. So if you had a word or two by way of summation, we'll then turn to the appellee.
Your Honor, the rule that we're seeking, which has been adopted pursuant to Malin in his paramount legal treatise on legal malpractice and ethics, is the continuous representation rule as it relates to the ongoing representation arising out of the same transaction. But we recognize that we're asking for a sea change. But that sea change would lessen litigation, I respectfully suggest, because it would allow the trusting, confidential, virtuous relationship between an attorney and client to continue to be curative. Otherwise, clients, especially in this day and age, who may perceive that their attorney has done wrong, may fire their attorney, sue their attorney to no end. And we believe the virtues of the continuous representation rule well outweigh the fears of stale claims. Thank you, Your Honors.
Counsel, quickly, one question, if I may. What you're asking, the sea change, is this not more appropriate for the General Assembly as a legislative fix, as opposed to you asking us to alter the statute of limitations, which were precluded under the Constitution?
Respectfully, no, Your Honor. Tolling principles are present at common law, not by statute, generally speaking.
Thank you.
Thank you, Your Honors.
Boyer Cohen.
Good morning, Your Honors. The sole issue before this court right now is just whether to adopt the continuing representation rule to toll the statute of limitations in a legal malpractice claim. Mr. Weisberg has advanced no sound or persuasive reasons for adopting such a rule or overturning the longstanding precedent of Moore versus Juvenile. In the Commonwealth, we already recognize the tolling exceptions of the discovery rule and the fraudulent concealment doctrine. These rules operate effectively to protect clients, and they obviate the need for any lawyer-only rule. Now, Justice Weck asked Mr. Weisberg why they didn't work in this case, and that's because his client already knew about the alleged malpractice long before. And the Superior Court made that determination, and that issue is not on appeal to this court. Therefore, those principles apply to bar his client's claims. So at this point, the only avenue that Mr. Clark may potentially have would be adoption of this attorney-only rule, which, as Mr. Weisberg admitted, would only actually allow one claim, which is the breach of contract claim. The legal malpractice negligence claim would even be barred by the continuing representation rule in this case. He also referenced Mrs. Clark. However, her claims aren't even at issue in this appeal. The trial court dismissed her appeals not on a statute of limitations issue, but on the fact that she couldn't prove a case within a case in the underlying action. The Superior Court affirmed that, finding that there was no basis to overrule that, and that was not appealed to this court either. So therefore, Mrs. Clark's claims were already dismissed on a case within a case basis, not statute of limitations, and would not be saved by a continuing representation rule, which only applies to statute of limitations.
How many, is this a minority rule, an extreme minority rule? How many states have it?
At this point, 26 states, not including Pennsylvania, have either refused to adopt the rule or have outright rejected the rule. So at most, it's not, so the majority of states have not adopted the rule, contrary to Mr. Weisberg's claims in his brief.
Fairly even split between the states.
And Your Honor, even in the states that have adopted the rule, many of them have adopted a modified version of the rule, in which case the rule does not apply if the client knew or should have known of the alleged malpractice during the time. And that is the same effect that is reached by the application of the discovery rule in our jurisdiction, which again obviates the need to have an additional rule.
Counsel, could I jump in following up on something Justice Behr asked? I'm not sure that this case is a proper vehicle in any event, and I see some problems with it. But assuming we can get to the merits here, and assuming we take a stand on the rule one way or another, could you comment on something that came up in appellant's argument, specifically in the practice of law, the scenarios which we might want to think about, for example, in family law, in episodic custody engagements, where there's recidivist disputes between the parents until the child reaches the age of majority, and a particular lawyer is periodically consulted and periodically used for motion practice, how the continuous representation rule should or should not apply in such scenarios, or why it should or should not be adopted in the view of that relationship, and also in the case of somebody who is running periodically into criminal problems and consults episodically a particular criminal defense lawyer in connection with such problems on sort of a rolling haphazard basis. How would that fit into this case? Could you comment on those?
Yes, Your Honor, you basically have hit the nail on the head as to the negative consequences of such a rule. It leads to ongoing litigation, which doesn't even exist now, as to what is the determination of the termination date for that representation. And it varies depending on whether it's litigation, whether it's, what type of litigation, whether it's transactional work. And possibly in situations where there is a very clear end of representation closing letter, which, does not always happen. And so in every other case, you're going to have the question, which has to be litigated. So a court or jury is going to have to then determine the termination date for the attorney-client relationship, because there's no bright line rule. Is it the close of a transaction, or is it the negligent drafting of the document? Is it the first time the attorney consults with the client and then there's a gap? Does that mean that there's a new representation? Is it a continuing representation? Another big problem would be a situation where an attorney is representing a client, is in the middle of either some litigation or the representation, and he leaves that firm. At some point, the representation ends, and the client wants to assert a malpractice claim against both the attorney and the firm. Well, does that mean that the statute of limitations had already run on the firm after the attorney left? In which case, there would have to be two suits brought at different times, which could result in inconsistent, verdicts. Does that mean that the firm has to plan for some potential claim down the road based on an attorney who doesn't work for them anymore, and not knowing what even happened with that litigation? I mean, that's happening more and more today with attorneys moving firms repeatedly during their careers. So basically, this just is an unworkable rule, because slight difference in facts could yield very different results. And so there would be no bright line rule that anyone could rely on to determine when this rule starts. At this point, the discovery rule and the fraudulent concealment doctrine operate effectively to protect clients. They are indiscriminately applied to all claims, including malpractice. And as this court is aware, the discovery rule in particular is very vibrant. Courts have not hesitated to find that the discovery rule presents a question of fact for juries as to when the statute of limitations run. And we've seen it in many cases recently, in Ray Risperdal, Carlino versus Ethicon, Nicolau versus Martin. And this discovery rule provides a substantial check on the statute of limitations that benefits clients.
Can I interrupt for 1 second?
Sure.
Regard to, this is Justice Monday, and I'm sorry for throwing you off the discussion, but with regard to the discovery rule, still a problem, because you may have some scenarios where the attorney may not agree that he committed malpractice. And likewise, in a case where he may feel he did not handle the case properly, doesn't that delve into the duties of an attorney to the client during representation? Isn't all those scenarios a problem with the continued representation rule?
I'm sorry, Your Honor, you were cutting out a little bit, so let me just make sure I understand your question. You were asking whether the client or the attorney's duties to his client are implicated with respect to the continuing representation rule?
Yes, and it comes down in two different scenarios. One where the attorney agrees that he may have not handled the case appropriately. And likewise, it arises in cases where the attorney feels he may have mishandled the case.
Well, Your Honor, I mean, these rules are also, or those scenarios are also implicated with the current exceptions, the tolling exceptions. In the situation where an attorney does not feel that he committed malpractice, then, you know, that would obviously be a factor to consider with respect to whether the client knew or should have known that the attorney committed malpractice. Or if the attorney tells the client that he did not commit malpractice and that everything's going to be fine. That goes back to the fraudulent concealment doctrine, where, you know, the client was lulled into a false sense of security and, you know, sat on his rights. So these situations are already encompassed in our current tolling doctrines that are already recognized and have been in effect for at least 125 years. So, you know, the continuing representation rule then begins to focus on, you know, the termination of the representation, which is an entirely extraneous event to the cause of action and to the statute of limitations. And again, it leads to even more litigation than is currently encompassed in the rules that we recognize. And the continuation of the representation could also be a factor to take into account in determining whether to apply the discovery rule or the fraudulent concealment doctrine. Again, based on what the attorney has represented to the client, or, you know, what the client knew or should have known based on the information that was given to him. And one of the you know, reasons given for adoption of the continuing representation rule is that, you know, you don't want to affect the relationship or, you know, disturb the relationship in the event that the attorney is attempting to fix the error. But in situations where the client already knows or should have known that the attorney has committed malpractice, that relationship is already conflicted and fractured. And so requiring the attorney to take some action is no different than letting them just sit and wait it out. The client, and also, you know, the client is still going to take the position that is necessary for the client to win in both the underlying case and the malpractice case. So whether that's a conflicting position, it's still going to happen regardless of whether the client, you know, brings suit initially or doesn't. So the reasons.
Counselor,
yeah, yes,
Counselor, it's Justice Donahue. Can I just follow up on what you're talking about now? Because we have the case within the case requirement in Pennsylvania, how does that interface with this? Let's say that, you know, you have a client who determines in the midst of a litigation that a statute of limitations on a potential defendant was missed. What happens then? The client sues the attorney who missed the statute of limitations because they knew immediately because of a summary judgment motion or something of that nature. Doesn't that case have to go to fruition in order to determine whether or not the client actually has a damage claim? I mean, let's say the statute of limitations ruling of the Court of Common Pleas is overruled. And we have a pending lawsuit against an attorney for blowing the statute of limitations. Client can't win that case because there are no damages. There may have been malpractice, but there are no damages in a contract action. If you don't have damages, you don't have a contract action. So how do those two things interface?
Well, Your Honor, first of all, there can still be potential damages arising from malpractice, even if the attorney somehow mitigates against his malpractice. For instance, the costs of an appeal in that case that wouldn't have had to be taken if the statute of limitations hadn't been blown would be damages as a result of the malpractice. So
what kind of lawsuit is that? I mean, really, it's just speaking in practical terms. I mean, doesn't the case within a case requirement in Pennsylvania create a situation where, although the client has to file a lawsuit when he or she knows that there's been malpractice, prolong the conclusion of that lawsuit until it's determined whether or not there was indeed a claim that comes to fruition? I'm not suggesting that that might not be all right, but the occurrence rule does not really provide a remedy for all of the potential downfalls associated with this kind of litigation, because we have a case within a case rule. Nothing is over quickly. You have experts who hypothecate that this case was not winnable or this case was winnable, as opposed to having the case go to fruition. So I'm just a little bit concerned about this notion that the occurrence rule takes care of all of the problems involved with legal malpractice cases.
Well, Your Honor, the current statute of limitations, again, is 2 years for a negligence claim and 4 years for a breach of contract claim, which means that the client has 2 to 4 years, for instance, in your scenario where there's a summary judgment granted because of the statute of limitations. So the client can wait the 2 to 4 years and wait for the potential appeal to finish before bringing the action. And generally, that will be accomplished within 2 years. In the event that the Superior Court would somehow overrule the trial court and take it and send it back, then there would be no claim at that point. But in all practicality, if an attorney blows the statute of limitations, generally that's not going to be resolved in the client's favor at that point. I mean, the statute is the statute, and if the attorney blew it and there's no basis to find otherwise, it's not going to be reversed anyway. And I mean, that's true, I think, for many of these malpractice claims. For instance, in this case, the claim is that my client failed to introduce certain evidence, should have called additional witnesses, and should have called a different expert. To the extent that was true or would have been true, that's not going to result in a change in Mr. Clark's favor on appeal, because at that point, the record is what the record is in front of the appellate court, and they are not going to allow additional witnesses or additional evidence or remand for additional evidence or additional witnesses because the attorney failed to call them. So in all practicality, many of the claims based on attorney malpractice are not going to easily resolve in the client's favor anyway. So it would be safe, for them to potentially wait for, the 2 years to see if the appeal pans out, but they still have that amount of time. And again, that's only if they knew of the malpractice. If the attorney is telling them that he's, everything's going to be fine and he's going to file an appeal and it's going to get reversed, then the fraudulent concealment rule comes into play and there wouldn't be an issue regardless.
Thank you. Well, unless there's any questions, we appreciate the argument of both counsel, and we'll take the case under advisement and take again a 5-minute recess and call the third case of the morning.
The next case is in the interest of J.J.M, a minor. Representing J.J.M is Mr. Robert M. Butner. Representing the Commonwealth is Mr. Jerry Scott.
Good morning. In this case, a 15-year-old high school student was convicted of terroristic threats for stating in a public high school while school was in session that he wanted to beat the record of 19. This occurred shortly after the Parkland mass shooting. Whether a terroristic threat made with a reckless mental grab is protected speech under the First Amendment. Mr. Butner.
Yes, thank you, Chief Justice and Associates. I'm Attorney Robert Butner from Scranton on behalf of the Public Defender's Office of Luzerne County, representing this juvenile petitioner. Your Honors, today we're here before the court asking this court to come up with a workable balance to afford rights to individuals to express unpopular opinions or desires, while at the same time protecting others from terror or intimidation. It is our position that that balance cannot be met merely from just evaluating the contextual circumstances from an objective point of view, but rather must also include an analysis of the subjective specific intent of the speaker. The First Amendment serves the purpose of protecting unpopular views and opinions, and we are trying to come up with a standard to ensure that the views and opinions are not arbitrarily suppressed or regulated by a narrowly drawn standard. And this can only occur if the most rigorous standard of evaluation is to apply. To effectuate that balance and bring the expression of an opinion, whether unpopular or sophomoric, requires the specific intent of both the communicator, the communication being made, and the intent to intimidate or terrorize. Just applying an objective recklessness standard casts too wide a net. The recklessness standard is objective and evaluates the speaker's mind only from a reasonable person standard, from what we expect a reasonable person to know, not merely about what the surrounding circumstances are when they make the statement, but also the effect that it might have on other people. In other words, reading other people's minds. That is why we submit to the court that the evaluation should not simply be context-driven when the recklessness standard is being applied. The juvenile in this case, I understand, did make a statement that he wanted to break a record of 19, Your Honor, but distinguishing this case factually from other cases, the minor did not say, well, first, let's go back to his first statement that was attributed to him, that all people should die. The juvenile did not say, it is my intent, or I will make sure that all people die. 2 weeks later or 3 weeks later, unfortunately, around the time of the Parkland shooting, the juvenile made a statement that he wanted to break the record of 19. He did not say, I will break the record of 19.
Mr. Butner.
Yes.
Justice Todd.
Your Honor, I apologize. It's breaking up.
Can you hear me now?
Yes, I turned up my volume.
Don't you have to ask? Or I don't know if it's fine. Don't consider the fact that comments were made in a school setting where there is a heightened sense of concern, particularly given that there was right before that a major school shooting, a major school killing, and also that constitutional rights are somewhat more limited in a school setting.
Well, Your Honor, of course, if this were the case such as JS, where this court evaluated whether or not an individual student can be expelled for conduct, I would say that is true. And by the way, I'd like to note I did miss some of your statement. It did break up a little bit, so if I'm not addressing that, please let me know.
It was a part of the question.
that a student's rights within a school are somewhat limited. Okay, and that would apply with regard to expulsion. But when we step into the criminal arena or the adjudicative juvenile arena, I believe that the student is still entitled to the same panoply of rights that an adult would be, or another juvenile, had the statement been made outside the school. For example, and I hope that answered your question, Your Honor.
Yes.
Mr. Butler, Justice Baer, can you hear me all right? Okay, well, I couldn't hear you, but we'll assume you're hearing me. Was this juvenile charged under 2706A1 for with the intent to commit an act of terror?
Judge, I apologize. It was skipping, and I don't know what's going on with my system.
Let me try one more time, and if my question was whether this defendant, this juvenile, was charged under 2706A for committing a terroristic threat with the intent of doing so.
He was charged with that, Your Honor, and he was found, he was adjudicated not guilty, shall we say, in the juvenile arena.
All right, so I wanted to straighten that out, but I got lost a little bit in your opening statement. Do you believe this is an objective or subjective test?
As it stands now, following Commonwealth versus Knox, I believe that it is an objective test that is being applied. If you were to extend that to the recklessness standard for which this juvenile was adjudicated, it requires an objective evaluation of what a reasonable person would do. That makes it objective.
And again, are you advocating for objective or subjective? I'm trying to understand the argument.
Both, Your Honor. I appreciate Justice Weck's suggestion in his dissent in Commonwealth versus Knox, where he employed somewhat of an objective test in his first factor with regard to considering the context or the context and circumstances in which the statement was made, and if indeed there was a question of whether or not a true threat had occurred, then the evaluation to the specific intent of the individual was evaluated, which would be a subjective evaluation as opposed to the initial objective evaluation. I would love for the court to employ the Ninth Circuit's straight de facto test that requiring a specific intent. However, because of the split that has occurred between all of the circuits, I'm hopeful that this court will expand its view and adopt the Ninth and 10th Circuit and follow Justice Wecht and Donahue's lead in their dissenting opinion in Commonwealth versus Knox.
All right, thank you.
Any other questions? Thank you, Mr. Scott.
Thank you, Your Honor. May it please the court, Gary Scott, representing the Commonwealth through Luzerne County DA's office. Your Honor, it's our contention that this was a series of conscious decisions. This wasn't a juvenile having an accident. Two main points that I would make. First, with regard to recklessness, that recklessness is a very different standard from negligence, which it appears that the defense seems to be leaning toward. I believe in the brief they say that it's a standard almost akin to negligence. We would disagree. Second, we would argue that the Knox factors would be met in this case by the juvenile's reckless behavior. So moving to the first point, this does involve a conscious disregard of substantial and unjustifiable risk. It's not purely evaluated based on what an objective, reasonable outside observer would determine. Justice Alito, in his dissent in Alonis, pointed out that previously the First Amendment has been used to screen out statements made in reckless disregard of their falsity. Justice Thomas, as well, in his dissent, had pointed out that, I think pretty apropos for our case, joking threat of a student to kill his classmates, again, wouldn't be innocent conduct. Secondly, with regard to the specifics Knox factors, first on the conditionality, he did say that everyone should die, and then followed that up with wanting to beat the record of 19, not wanting to beat it if the stars aligned or he felt like it at that particular time, but we would characterize that as unconditional. These were not directly
Counsel, I'm sorry, Justice Baer, before you go too far, in Knox, we determined that there was a specific intent to terrorize, to threaten the police officer involved, premised upon the lyrics that named the police officer and said what he's going to do to the police officer. Here, the juvenile was found not guilty. I'm using adult parlance, but not guilty of intent to commit terroristic threats. So it seems to me to be vastly different. I don't know that Knox is good precedent for you, given the fact that evidently, premised upon the state of the record, this juvenile did not intend to terrorize anybody.
Yes, Your Honor. He was found not guilty of having intent. I do believe that the Superior Court, in its opinion, believed that there was enough to show knowledge. In one of its footnotes, it had pointed that out. Even so, I would say that at least the same kinds of factors that were used in Knox to discriminate between true threats and non-true threats would still be useful in this case, because in both cases, some of the policy concerns that are implicated, for example, the desire to protect people from the insecurity that comes from those threats would be the same. There's a specific phrase, I don't recall it offhand, but I think it's that to protect the public against the fear of violence engendered by terroristic threats.
Well, that's. Can I follow up? But that's there's a whole lot of stuff out there in the world that can put us all in fear, isn't there? There's a lot of irresponsible talk by adults, let alone by teenagers, right? Doesn't your standard allow law enforcement to sweep in arbitrarily with an incredibly wide net whoever is deemed unpopular, or to use high school parlance, quote, a weirdo? There are all kinds of things muttered by teenagers. And what if another teenager doesn't like that kid, or they're unpopular? How is recklessness an adequate standard given the primacy of First Amendment protections? You mentioned consciousness. Doesn't that necessarily mean we need scienter? We need intent in order to criminalize speech in this country?
Not, Your Honor, not. So if I could answer those in sequence. First, I wouldn't say you would need the specific intent to threaten. I think that the mental state that would be required would be, however, conscious disregard of a risk. So there has to be awareness that the risk would exist. But I don't think that we would go further and say that you need specifically to threaten the other person and want the person to be threatened. With regard to the school, or the fact that people sometimes make statements that are irresponsible, we would have two responses. The first one would be to point out that it does not appear, so in most of the federal circuits prior to the some of the interpretations of Black that allowed a subjective component in, and as well the subsequent aloneness, which again, some of the circuits interpreted as bringing in a subjective component. Prior to that, as I understand it, most of the interpretations of the law were allowing a purely objective standard. And so I don't know that in practice there was a massive persecution of people with unpopular views or anything like that. But I suppose that's more of a policy question. But as to the specific jurisprudence in Knox and in the cases preceding it, what we would say is that context does matter, that context has been brought in frequently. Even in BR, for example, which I believe I believe as amicus, the ACLU had brought up, there was the recognition that, or no, excuse me, I apologize, the 1999 case, its name I'm blanking on, but in any case, there's been a recognition that schools are a slightly different context from political rallies. That in political rallies, sort of violent speech is more common and it doesn't often lead to physical violence. Whereas in schools, you're much more concerned about that because there's a long history of school shootings.
Well, there's nobody that's not concerned about school shootings. That's not what this case is about. It's not a measure of the temperature of the court on whether any of us care or don't care about school shootings. It's not about slogans. It's about the First Amendment and its reach. You mentioned Watts. If recklessness was enough, if recklessness was enough, how could you not argue that SCOTUS would have upheld Watts's conviction? It was clearly reckless. But they dumped the case. It's the intent. It's the intent that we need to demand, isn't it, in order to withstand a violation of the First Amendment. Otherwise, if you go, one more thing on that, if you walk down the hallway of any school in this country and you're listen in, you eavesdrop on student conversations, aren't you going to hear reckless talk every day of the week? If not, I guess your schools are different where you're sitting.
With regard to the Watts case, Your Honor, I would respectfully disagree. I think that in Watts, the statements would not have been reckless because in addition to the various other factors that Knox would later consider, the context of that would have been a highly politically charged rally. The people who were listening to Watts speak immediately responded with laughter rather than fear or anger or horror of his alleged threat to the president. I don't believe that would be reckless speech. I don't believe that within the context of a political rally, he was consciously.
I'm sorry, finish your sentence. I'm sorry.
Oh, I apologize. I don't believe within the context of a political rally, he was consciously disregarding that substantial risk.
Thank you. Mr. Scott, with respect to intent, do you view it relevant, or what kind of a factor would you say it is that it was found that this individual, this juvenile, had a reputation for having a fascination with death or being excited at the thought of death? Is that part of your analysis, or would you regard that as irrelevant?
We would regard it as relevant, Your Honor. He does seem to have kind of gone out of his way to apprise other students of his interest in death, and that would go toward the conscious disregard of the substantial risk.
Counsel, Justice Doherty, permit me. I have a question. Follow my theory. So the question before us is very myopic, whether reckless prong of 2706A3 conviction or adjudication violates his First Amendment rights. Now, we already know that he was found not guilty of A1, so that knocks out the terror portion of 2607A3. Therefore, what he's been convicted of was causing serious public inconvenience. As a result of that serious public inconvenience, if we follow Justice Weck-Donohue's dissent, and even the Knox's holding that we want to take it above negligence but let's look at the circumstances and the context. Share with me how this conviction doesn't violate his First Amendment when, in fact, you take the first comments, everyone should die, that was 4 weeks prior. You take the current comment that day in school, I want to beat the record, and you take the factual basis that's before this court that your school did nothing for a period of time. How, in fact, do those, as a matter of law, meet the facts or meet the factual basis or the requirement of serious public inconvenience? I'm failing to see how over a 6-week commentary period, 2 comments made over 6 weeks, results in a child not only being convicted, but then finding that the child needs to be treated, supervised, and rehabbed. The concept of what he wears is incumbent of the school to treat counseling and his fascination. But let's get back to the issue before us. Share with me how you are able to argue where was the serious public inconvenience, taking into the subjective or objective prong, despite whether you want to go with the Knox majority or the Knox dissent. Contextually, share with me.
Okay, so the initial statements, as I recall the record, were not brought to the school's attention until after the second statements weeks later about breaking the record of 19 had been made. So once that happened, the public inconvenience and alarm would be the 2 students who were put in fear as a result of the statements, and the fact that the school itself was disturbed enough to have to go for expulsion proceedings, which I think it did within a short period of time consistent with its policies and procedures in expelling students.
The child remained in school that very day, correct? I believe that's what the facts, the briefs indicate.
I'm trying to think back to the record. I'm not sure whether he was kept in school after the point when those statements were initially made.
Fair enough.
Can I follow up on just briefly on Justice Doherty's question? Why is this the case that's the exception to the rule that we don't allow propensity evidence? I mean, aren't you basically arguing this is a bad egg? We've been watching him. So unpopular people, it sounds a lot like the argument they made against witches 400 years ago. He's a bad guy. The First Amendment doesn't apply to him. Why do we allow propensity evidence in this case?
Your Honor, we wouldn't be admitting it or arguing that it would be propensity evidence. In other words, he is the kind of person who makes threats generally, therefore he made a threat in this case. Rather, we would use it to show, basically it would be the effect on the listener, that when you routinely talk about death and people dying to the people who receive the communication, that those people would, as reasonable people, be concerned about it. So it's not that he's the kind of person who commits crimes, therefore he's committing it in this case, but rather that he's making statements that over a period of time that put others in fear and would put reasonable people in fear, and that he consciously disregarded that risk.
Counsel, this is just Donahue. You continue to conflate the first issue, which is the impact on the hearers or the recipients, with the subjective intent of the speaker. And when you talk about context, you do the same thing. I think what we're trying to grapple with here is the second element that we identified in Knox, which is the intent of the speaker. And my question to you is, since we are dealing with content-based speech, doesn't the First Amendment require us to look to the least intrusive mechanism in order to control the alleged harm that's in play? And isn't the least intrusive mechanism available to the government in this context to find specific intent to create the threat?
So I would initially apologize for being unclear with regard to distinguishing the two factors that you had described. So the intent of the speaker, there was sufficient evidence found below that he had consciously disregarded that risk of frightening others, and so that would be the I suppose the subjective element, that he was making these statements. He realized that these statements might, or he had knowledge that making these statements would create a substantial risk of fear, and he consciously disregarded that risk in making the statements. So I don't think that sufficiency has been challenged in this case. So I'm proceeding on the assumption that he did in fact have that, or that he did in fact consciously disregard the risk with those facts in mind. And given that the school shooting that had happened only a couple of days was before him, he had previously made these statements. I don't believe that a specific intent standard would pick up those kinds of problems, similar to the dissent that Justice Thomas had made in Alonis, where he pointed out the scenario of the joking student who threatens to shoot all of his classmates.
I agree with you, counsel, but my question to you is, doesn't the First Amendment require us to use the most constrained restraint available on this content-based speech, and the least intrusive standard in this context is in fact intent? I mean, you have described recklessness as the Superior Court described it. The question is that good enough for First Amendment protections? Doesn't the First Amendment, I'm asking you, doesn't the First Amendment require us, and tell me if I'm wrong, doesn't it require us to look to the least intrusive way in which speech will be impacted?
Well, yes, as to the general point, the First Amendment has, yes, traditionally been interpreted to have the least restrictive, or the least restrictions possible, but again, consistent with the obligation of the law also to criminalize that speech that actually does cause the harms that reckless behavior does. So in this case, for example, I don't believe that applying a specific intent standard would catch some of the problems that, as I mentioned, Justice Thomas had pointed out. So it would not be the least restrictive standard that would actually prevent the harms that you're looking to prevent.
Okay, thank you.
Counsel, Justice Baer. I should have asked opposing counsel. In all candor, it was difficult to hear him and I was missing answers. So let me try with you. This is being argued as an as-applied challenge to 2706A3, that under the facts of this case, and I think the issue was actually stated that way, under the controlling facts of this case, that this adjudication would be unconstitutional. Do you see it that way, or do you see it as a facial challenge to A3? Because I'm not quite sure if we reverse in this case, what vitality is left to A3.
So I wouldn't want to speak to Attorney Butner's own legal theory. As I read it, I guess I would interpret it more saying that it would be as applied rather than a general challenge to the recklessness standard. But again, Attorney Butner would be the one to speak to that. I of course tried to argue both in the alternative that I didn't hear you.
No, that's all right. We generally don't allow rebuttal. I would have the discretion to ask him, but I'm not going to. I'm not going to violate that long. tradition of our court, and I'll figure this out in due course. But can you think of other facts, and I won't belabor you. I appreciate that you're arguing the other side a little bit. Other facts where you would be able to sustain a conviction for causing serious public inconvenience with a reckless disregard of causing inconvenience.
So other facts, I mean, I don't know how far Your Honor wants me to diverge from the facts that we're here for. I mean, I would say that the example that I had used frequently from Justice Thomas's dissent would be a very good one, where the student is joking. He intends it's humor. It's not, he's not specifically intending to frighten people, but nevertheless, he consciously disregards the fact that his saying he's going to shoot his classmates in a letter to a principal or something like that would in fact cause fear or terror or alarm. So
could I follow up then on Justice Baer's question? Isn't it also the case that for purposes of looking at A3, that one can communicate a threat by action, including by physical act, rather than by saying something, in this case, under one's breath in a school hallway to no one in particular? Isn't that a very different fact scenario?
So communicating under one's breath to no one in particular would be a different factual scenario than the one at issue here, because I don't think that he was talking to someone and it was overheard. With that being said, yes, I think that communications can be made non-verbally. Those are more prone, I think, to being misunderstood than verbal ones.
Thank you.
Chief, I was just going to say I appreciate that. I was asking for an argument that may be best made by the other side. So I appreciated Mr. Scott's efforts to answer.
Thank you, Your Honor.
Okay, thanks to Mr. Scott. Thanks to both of you. And
shall I mute it then? Or?
We have the case. So we're going to take a 1 hour recess and reconvene at 1 o'clock.